Good morning and seasonal greetings, Your Honor, and opposing counsel. I speak and rise on behalf of the petitioner who extends his sincere gratitude for the court's grant in discretion of this motion for reconsideration on the matter last heard a fortnight ago, regarding a motion for summary judgment brought by the petitioner and counter-demurrer filed by the Commonwealth Attorney at the midnight hour, having successfully managed to evade service of process by both the sheriff for the city of Alexandria and a commercial process server retained at the expense of petitioner for a span of about a half year. And we shall make this brief so that all may get off to enjoy the holiday weekend with due precautions in recognition of the current public health crisis. Looking forward to come in years. Christmas is more merry and New Year's more happy, certainly. Petitioner would wish to express his great alarm at a state of rule of law, particularly immediately after an election where a popularly elected prosecutor had run unopposed, claiming as much as 97% of the popular vote, prompting his reply to the newspapers that it was an indicator that he must be doing something right, given the record before the court, which provides abundant evidence to the contrary. The petitioner, while certainly not a licensed nor practicing attorney, stands in appalled and aghast at the thought that a prosecutor and a city attorney who had drafted the order after his dismissal from the case might not find some cognitive dissonance in the words contained therein, indicative of a clear misunderstanding of the judicial standard for a grant of motion for summary judgment, much less an ability to recognize the distinction of material facts recognized by this court as a subject for further inquiry on the same page where it was recorded a grant of demurrer on a claim that the complainant might have failed to have stated a legal cause of action, wherein therefore would lie the material fact previously indicated in the order. A simple question. Petitioner finds this no less concerning that a prosecutor popularly elected who might deign to proffer the argument that he enjoys complete discretion, contrary to controlling statutory authority, that he enjoys complete discretion as to what matters he might choose to investigate and prosecute, where the black letter law, known even to the unrepresented petitioner, expressly distinguishes between misdemeanors, which remain at the discretion of the prosecutor, but mandate compulsory action for felonious conduct brought to the attention of the Commonwealth Attorney, for which, on the record before the court, there has been established more than ample notice, so much as to trigger a pattern of evasion which the prosecutor has willfully also chosen to ignore heinous allegations of federal crimes, including conspiracy to evade a summons and particularly in this progressive jurisdiction, conspiracy to violate civil rights. Nothing further, Your Honor. Opposing counsel, Merry Christmas. This advertisement was authorized by Mike Webb.
Thunk, I could have had a vaccine.